Okay, I'm going to go ahead and get started with today's presentation. This is the Spring 2019 Employment Law Update from Horton Law. My name is Scott Horton, the founder and attorney with Horton Law. We've been in operation for about 2 years as Horton Law. I have about a dozen or so years of labor and employment law experience before that. Many of you are familiar with these webinars, which we try to do several times a year, not quite monthly, but we approach that. We also send out an email newsletter. So if you have registered for this webinar, then you will also receive the email newsletter. The topic today will include both federal and New York state laws. I think everyone that has registered for this webinar has employees in New York State. You may have employees elsewhere, but the structure is such that if, for example, you decided to participate and don't have New York employees, the first segment will cover federal laws and proposed regulatory changes, and then we will talk about New York specific issues later on, mostly at the New York State level, but I'll also comment on some local laws affecting certain areas of New York State, both for people who have employees in those areas and also by way of showing what might be developing at the state level in New York as we go forward. So again, we thought that this was a good opportunity to give everyone an update of what is transpiring, as there is a lot going on, things that have happened, things that have not yet happened, things that may still be happening. We want you to know the rules of play as we enter the 2019 season, so to speak. Again, I kind of went over this. We'll talk about federal and state topics. If you have any questions about any of these or other topics, I will try to answer those at the end. Please type your questions in. You're welcome to do it any time throughout the presentation, but for the most part, I will wait until the end for a question and answer segment. If there's a particularly relevant question or something that will help us transition well, I might try to fit it in, but we will try to leave that primarily standalone so I can get through all the material in the time allowed so we don't keep you too long. I will stay as long as possible to answer questions at the end if you have them, but overall we should wrap up in about 1 hour. Several federal issues that we need to go over, and then various state topics as well. They're on this list, but we will go over them more as we get to them, obviously. The first topic I want to update everyone on is something that will not necessarily pertain to everyone's organization who's represented here today. So actually, I thought I would throw up a poll here to ask if your organization is required to file EEO-1 reports. So I'm putting that up. As that's up, I will briefly note that employers in the U.S. with 100 or more employees are expected to file EEO-1 reports each year. Some smaller federal contractors also are required to file. So if you have 100 plus employees, your organization likely is required to file the EEO-1 report. So I did put up an option or two about whether you might not know, or maybe it's just not your job to file the report. But I just wanted to get an idea of the attendees as to who this might apply to specifically. And it's looking like right now we have about half of you saying, yes, you file the EEO-1 reports and you're actually involved. About a third are saying, no, you're probably smaller. And then some of you are just not sure, probably because it's not your responsibilities. Now we're tipping up to more than half overall are responsible, or someone else in their organization is responsible for filing the EEO-1 reports. Okay, so we will put a stop to that poll just so we don't get distracted and keep going. The reason I'm bringing this up is if you are required to file, well, first of all, if you're required to file and haven't been, then I want to make sure you find out about that and get to it. We are in the filing period for the 2018 report, so you file for the previous year. And what historically you've had to report in the EEO1 is categories of employees broken down by race, ethnicity, gender, and occupational category. How many employees you have, for example, that are women in a certain management category. So that was what we've done for years until 2016, when the EEOC modified the requirements to include wage and hour data. That was supposed to begin with the reports filed in 2018 for 2017, but as you all probably recall, between 2016 and 2017, the administration in Washington changed. Not only individuals changed, but the party control shifted, and that presumably contributed to the OMB in 2017, before the reports were required to be filed, preemptively suspending the pay data collection aspects of the new form pending further review based on the burden on employers and privacy concerns. So as a result, the 2017 and 2018 filings that would have been made in 2018 and now in 2019 have not, the forms provided have not included the field to submit the wage and hour data as proposed back in 2016. However, last month on March 4th, a federal judge in DC ruled that the new EEO1 form, the one from 2016, including the pay data requirements, shall be in effect. And I quoted the ruling directly because that's what the judge said, and that's about all we know at this point of exactly what it means. So now the pay data requirements are in effect. The filing period is open, but as a real practical matter, the EEOC has not made the new form available. So if you have filed, or if you try to file now through the EEOC website, you will find that you cannot submit the pay data. You can only submit the traditional gender and ethnicity and race and job category data. The effect of the court ruling is that you probably will have to file that pay data. So if you've already filed your EEO1 for 2018 or do so in the near future, you may later have to amend, but we are not yet sure exactly whether and when that will be the case. The court is still working with the EEOC and the various interest groups that filed the lawsuit to try to work out what this is all going to mean. The EEOC recently suggested that it would take until September 30th of this year to collect the data. At present, the filing period ends May 31st of 2019. It seems unlikely that the EEOC is going to have the new forms and procedures in place for employers to file the new data by then. They may have to extend the filing period, reopen an amended filing period, or take some other action. I would say fair to say that the interests on the other side don't think that it should take the EEOC until September 30th of 2019. Yesterday, in fact, when I'm presenting this live on April 17th, the judge had a hearing and gave the parties until April 22nd to submit additional papers. So by next week, I suspect that we will have some ruling from the judge. So if you happen to be watching this in a recorded form later, there is a recording being made of this webinar. It's possible that something will have already changed. But that is kind of where we are. So you may, if you were about to file this week or next week, your EEO1, want to hold off to try to determine what you will need to do. But if it gets into May and you still don't have better direction, you may want to look into it further because you don't want to miss the filing deadline if it has not been extended. Okay, so that was one update I wanted to give everyone. The other federal issues that I want to go over at this time have not yet taken effect. So everything at the federal level that hasn't already been in place for some time is still up in the air. But there are a series of topics where the U.S. Department of Labor has proposed new regulations interpreting the Fair Labor Standards Act, which is primarily the federal minimum wage and overtime law. There's other provisions, including child labor law provisions, but the proposed regulations that we're talking about at least don't have impact on those. They go towards primarily the minimum wage and overtime requirements. Before I get started on the specifics of the proposed rules, just to clarify, most employers and almost certainly everyone who is represented or every organization represented by the people participating in this webinar today are covered by the FLSA. Some smaller intrastate only family owned businesses, for example, might not be covered by the federal law. State laws also apply, including in New York, to many employers, but not necessarily all employers, even within the state. And I'll speak about that in a minute. But most of you listening to this webinar live or in recording can probably assume that your company is subject to the FLSA, whether you're a private or public governmental entity. So one thing I'm not going to spend a whole lot of time on, but there is a proposed rule out there on, is the joint employer standard under the FLSA. If you happen to be in an industry such as one that uses franchisees, and there's been McDonald's cases, for example, where the government has just argued with itself and with McDonald's and other chains like that as to whether the individual franchised restaurants and McDonald's corporate are joint employers of their employees for various reasons and under various laws. But this again would be specific to the Federal Fair Labor Standards Act, primarily the minimum wage and overtime, but also the other requirements of those laws. The current regulation refers to whether businesses are completely disassociated or not, which admittedly is a largely unclear standard. But the current administration has proposed to replace that with a 4-factor balancing test that would address the different issues on your screen to determine whether two entities are joint employers of particular employees. Notably, the test would focus on whether the proposed joint employer actually exercises this power, as opposed to whether they have the potential to exercise the power. That is frankly a distinction along political lines. So in the previous administration, especially the National Labor Relations Board, which is not the agency that oversees the FLSA, but also a prominent federal labor agency, the Democratic majority board took the position that just the ability or the potential for exercising these types of responsibilities could demonstrate joint employer status. So that's key. But what the current Department of Labor tried to do is identify the most tangible employment types of actions of hiring, firing employees, supervising, controlling employees' work schedules or conditions of employment, determining employees' rate of pay and methods of payment, and maintaining the employee's employment record. So just to use the sort of restaurant franchise example, if the corporate office provides an employee handbook and gives some suggestions on how many employees an individual restaurant should employ or staff at given times, it's likely that that would not meet this balancing test because they don't hire or fire directly, set the work schedules of individual employees, determine rates and method of payment, or maintain the records. All that would be done at the franchise E level. So for most of you, that's probably not a big deal. It could come into play if you have temporary agency employees on site, but by and large, in that case, somebody is making sure that the employees are getting paid minimum wage or overtime. But this is a proposal out there. It is important in certain industries and for certain employers, and it is a hotly contested political issue in employment law these days. Comments are due by June 10th. That is just an indication that the Department of Labor can't finalize and enact this rule before then, and it will probably take a little bit of time at least after that, but it is possible that new joint employer rules will take effect this year. Note that because this is a balancing test, the entity doesn't have to exercise all of these powers. They just would look at the totality of the circumstances, evaluating these factors to decide whether or not they are a joint employer. Okay, again, that might not be entirely practical for most of you, but it is out there and important. And you will hear about it if you're paying attention to employment issues in the press. So that's why I wanted to cover it. These next couple of topics could be more tangible. You will also hear about them in different ways, although this particular one is probably the least likely to get a lot of media attention or be discussed publicly. And what it is the Department of Labor has proposed changes to how overtime is calculated. So we're going to get to issues about exemptions, but before you get to whether or not the exemption applies, there's the basic issue of how do you calculate overtime for people who are subject to overtime under the FLSA. This is based on something called the regular rate of pay. For many hourly employees, you know, if they get paid $15 per hour and that's their only form of compensation, their regular rate of pay is $15 and they have to get paid overtime at time and a half, so $22.50. But for employees that might have different premiums and side forms of compensation and certain benefits that, you know, cross the line as into cash compensation at some points or by some analyses, for example, there are some gray areas. So, and that's what's being addressed here. The Department of Labor's proposal would expressly remove some items from calculation, which would really only have the effect of reducing the overtime rate in some cases where it has any impact. There are also some components of these proposed rules that would clarify issues related to paid meal periods, callback pay, and a couple of other things like that. I don't want to go into too much detail on this because, again, it probably won't apply to most of you, or at least most of your employees, and this is not final. There's still an open comment period until late May, as you see on the slide. After that point in time, the Department of Labor will have to consider comments submitted and issue final rules. And certainly if the final rules are going to have a significant impact, then we will provide more information through our newsletter and or later webinars on the topic. But just to give you a little bit more information, if you need it, I have put on this slide the various items that would now clearly be excluded from the regular rate and hence overtime rate calculation. So payments for unused paid leave, including paid sick leave, reimbursed expenses. I mean, again, some of these items have been in the category of things that shouldn't apply to the regular rate, and some are just more gray areas where there's disputes and different courts have held differently, or different Department of Labors under different administrations might have had different views. The biggest FLSA regulation proposal in the last couple of months that most of you have probably heard something about, and you might remember back in 2016 and before that when we went through this before, is the proposed salary level change. So this is the salary level requirement for overtime exemptions. Under the FLSA, we're talking about the executive, administrative, and professional exemptions that have these salary level requirements. The current federal salary requirements for these exemptions are on the left of this slide: $455 per week, $23,660 annually. There is a highly compensated employee exemption at $100,000 in total annual compensation. The difference between the $455 a week and $100,000 annual is that for people who meet the highly compensated employee threshold, the duties test for exemptions can be somewhat relaxed. In practical sense, the people that are meeting the highly compensated employee exemption are likely to satisfy the more extensive duties requirements of the traditional exemptions anyway, but there is that additional category in the regulations now. And this $455 per week threshold has been in place for a long time, many years now, and there are no automatic adjustments in the rules. The current proposal from the Department of Labor is $679 per week, which works out to just over $35,000 annually. They have increased the highly compensated employee exemption significantly by half, almost, to $147,414. There are some additional parameters on that, what can be included and what can't in the proposed rules, but again, for the most part, if you have employees making somewhere between $100,000 and $147,000, they are likely to qualify for the exemption as long as they are making the lower weekly salary threshold. But if, for example, you have people who don't get paid a standard salary and therefore can't qualify for those exemptions, you might need to look for the highly compensated employee exemption, with the further complication that the New York laws on overtime where they apply don't specifically include the highly compensated employee exemption. But I don't want to go down the path too far on that. If you have one of those cases, talk to me or your employment counsel and work it out. But again, these are only proposed rules, so probably better to wait until it gets finalized, because some items at the margins might yet get tweaked. The current proposal from the Department of Labor includes no automatic adjustments like the current rules, but there is a plan. They do suggest a plan for the Department of Labor to review the level every 4 years. So nothing would actually happen unless the Department of Labor proposed new rules and went through the comment period and then implemented a change, but they at least are suggesting that that be done every 4 years. Now I want to back us up a little bit by comparing what currently proposed in 2019 to what was not only proposed, but in fact implemented in 2016. If you remember back, many of you were aware of changes planned in 2016 that toward the end of that year would have increased the salary level for the exemptions to $913 per week, which you can easily see is significantly more than the current proposal. Ironically, the highly compensated employee exemption was scheduled to increase by less than what the Department of Labor is currently proposing, but again, that's not the most significant aspect of these proposals. The 2016 plan also included automatic adjustments every 3 years, and while the rules didn't specifically say it, the automatic adjustments almost certainly meant automatic increases in the salary threshold every 3 years, because it was based on the average salary level that automatically would go up every time that people had to satisfy the new salary requirement. So it was going to build on itself. The 2016 rules actually went all the way through the formal rulemaking process and were adopted. They were scheduled to go into effect in December of 2016, but right before that happened, a federal judge in Texas put a stop to it. So they are actually still being litigated. They are on appeal, but the appeal is on hold because the Department of Labor, which is no longer in support of the 2016 rule, wanted to have that litigation stand still so they could implement new rules. So that's why we have these new 2019 proposals with lower salary thresholds, again, including the now higher, highly compensated employee level. Comments are due on the proposed rules next month. So the Department of Labor will have to get those comments, review them, and then they will likely issue final rules. I anticipate they will finalize a new rule this year, but there's some optimism that they will both give a long notice period to employers before the new thresholds take effect, and hopefully will give a convenient transition date instead of 2016's early December implementation. You know, it would seem to make sense, for example, to have the new rules take effect on January 1st, 2020, perhaps. But that is something that the Department of Labor will have to evaluate and weigh in on when they issue the anticipated final rules. Okay, as most of you, if not all of you, have employees in New York, I want to circle back to what I alluded to before. And as it turns out, with the proposed salary level, there will be a less direct impact on private employers in New York because the state salary requirements for the executive and administrative exemptions already exceed the proposed new federal level. So if you have employees exempt now under these exemptions, they're already making enough money to satisfy the federal threshold. That was not the case with the 2016 proposal, so it was more of a concern in New York. It would technically affect the professional exemption because the New York professional exemption does not have a salary level requirement. Theoretically, you could have an exempt professional who's not being paid a salary or who isn't really being paid very much of a salary. At the federal level, the professional exemption does have the salary requirement, except doctors, lawyers, and teachers. So if you have professionals who are exempt under that exemption in New York and they're making less than the current New York salary requirement, that might be okay, but they might still have to receive the new higher federal salary when that takes effect. The public employers in New York State, government entities, state, federal, local, school districts, do have to meet, I said federal, I'm not sure the federal government would have to, but the other state and local government entities and school districts in New York are generally only subject to the FLSA, not the state overtime requirements, so they don't currently have to satisfy the state exemption levels. Many probably are, but if they are not, then they would have to come whatever effective date of the new rules we may end up with. The other thing to keep in mind, for example, both in the public sector, if you're in that area, and for the professional exemption in New York, while most people working full-time are likely to already satisfy the new federal requirement, part-time employees might not be. You might have an architect, for example, working half-time and making less than what the new federal threshold would be. There is no prorating for part-time employees. So regardless how many hours the employee works, they have to meet the full salary threshold. Okay, so now we're going to shift to the New York State level. So if by chance you have no employees and no interest in what goes on in New York State, then you could tune us out at this point. But I think most of you here do have New York employees. So with that, there are things going on at the New York level that look different from what is going on at the federal level. Most notably, you probably sense from what I just discussed, the changes at the federal level are all shifting toward relatively less regulation of employers especially as compared to the previous administration. At the state level, we are in decidedly the opposite situation, where now the state legislature in both houses and the governor's office are all in Democratic control, and they are all focused on, if anything, greater expansion of employee rights and protections. One area that did finally take effect as a statutory measure earlier this year is GENDA, the Gender Expression Non-Discrimination Act. This is a law that had been proposed for many years in New York. And what it does pretty simply on its face is add gender identity or expression to the categories protected from employment discrimination. So the New York State human rights law, in addition to protecting race, sex, age, disability, and a number of other categories, now expressly include protections for gender identity or expression. Before this, when Republicans in the state Senate essentially refused to adopt GENDA, the state, through regulatory action, had extended the prohibitions on sex discrimination to include transgender protections, gender identity and expression related protections. The interesting thing about this from kind of a technical standpoint, as I read the laws, is that it now creates some arguable ambiguity in laws regarding sexual harassment. As many of you know, there were a lot of changes in the last couple of years to New York laws regarding sexual harassment, including extension of employers who are prohibited from engaging in sexual harassment, where it was previously employers with 4 or more employees. Now it's all employers, even if you only have 1 employee. There's also protection for sexual harassment against independent contractors, where all the other categories only protect employees. And it's clear in the new sexual harassment training policies, or training and policy requirements, that New York State had intended sexual harassment to include harassment based on gender identity or expression. But I think there is a reasonable argument, maybe not one that anyone should be relying on as a general business matter, but if it push came to shove, I think there's a reasonable argument now that gender identity and expression are listed separately from sex and the human rights law protections, that one could argue that sexual harassment does not include gender identity or expression harassment. Again, I don't encourage anyone to try to make that distinction on a day-to-day basis, but it is at least a legal, technical issue that someone down the road might test if they were in litigation, for example. GENDA took effect on February 24th of this year. While it probably has little practical impact, because like I said, from a regulatory matter, New York already considered these types of issues to be protected, you should at least update your anti-harassment and discrimination policies in New York, where you list out all the other protected categories, to now include gender identity or expression specifically. Something even newer in New York and more likely to have a real impact on a number of New York employers is a change to the New York voting leave protections. This is actually in the New York State election laws. And the budget this year included a number of election law changes, many relating to who is eligible to vote in elections and how they do so, etc. But one aspect of that does directly impact all employers in the state, or at least potentially impact all employers in the state. So basically, the change expands employees' right to take off time from work to vote. It applies to all employers and their employees who are registered voters, and it does include paid leave. Actually, the law has always included paid leave, but as you're about to see, it didn't apply to nearly as many people as it now will. So here is a slide where I am comparing the old law with the new law. The old law said that employees could take time off to vote if they did not have 4 consecutive hours before or after work to vote. Many employees' schedules and shifts were such that they did have 4 consecutive hours either before or after work to vote. So as a practical matter, the law really didn't do much for them. The people who did not have 4 consecutive hours before or after work to vote were entitled to take sufficient time off to enable them to vote, with up to 2 hours of that time paid. So again, if you did happen to have somebody who didn't have 4 consecutive hours before or after work to vote, then they could take enough time off to enable them to vote, and the first 2 hours of that time would be paid. The new law is dramatically more expansive, primarily because the 4-hour criteria has been eliminated entirely. So it no longer matters whether they have 4 consecutive hours before or after work to vote. The law simply says that registered voters can take as much time off as necessary to enable them to vote. And if they do need that time off, employers now have to pay for up to 3 hours of that time instead of just the 2 hours before. So not only do employers have to pay more employees, but they have to pay them for longer in some cases. The real problem is there wasn't much of an issue before, didn't really come up all that much, so it never was all that clear of, how much time is sufficient to be able to work. And now there's an open question. Does this mean that every employee in New York is entitled to 3 hours of paid voting leave? Well, probably not. But as a practical matter, it's going to be hard to know how much they are entitled to. And the question is, to what extent will employers want to essentially argue with employees over whether or not they have enough time to vote outside of their work schedules? These questions, like I said, really hadn't been answered in the past, so it'd be interesting to see. I can note also on the slide that the time off is by default either at the beginning or end of their shift, unless both the employee and the employer agree to something in the middle. But it is going to be hard for the employer to say, no, you have plenty of time, or 1 hour is enough, because before the employee actually shows up to the polls and finds out how long the line is, etc., who's to say exactly how long it will take? There are a few more details to consider. Employers do, as they always have had to, have an obligation to post the notice of employee rights under the voting leave law at least 10 days before every election. Many employers will just find it practical to have that posting up year-round rather than bring it out every time there's an election. Employees, to be eligible for the time off and to be eligible to be paid, must tell their employer at least 2 days in advance of the election that they need time off to vote. So the law doesn't really appear to require employers to go around asking their employees, but if an employee does come up at least 2 days before the election and tell a manager or supervisor, human resources, or whomever that they're going to need time off to vote on election day, then the employer is going to need to have that discussion at least to try to determine whether they do need that time off, and if so, when and how it's going to be scheduled, and how much, if anything, the employee is going to get paid. And again, there are not any clear guidelines on what the employers must do in that situation. Which elections are covered? It's all federal, state, and local public elections being held in New York. General elections, primary elections, and special elections are likely all covered. School board elections probably are not covered. This will have potentially more impact even on employers based on where their employees live. There might be some areas that have elections and others that don't, especially if it's special congressional district elections or something like that. Again, another reason why you might just want to leave that notice of rights up year round. But again, at least the employee has to come forward and say, I want the time off, and the employer doesn't have to be the one saying, oh, I know there's an election coming up. It does have to be an eligible voter as well. And the consequence of not complying with this law, again, not very well spelled out, but it is a criminal misdemeanor for any person or entity to violate these provisions of the election law. And it is likely that if an employee does not receive pay for this time, that they would have a claim, whether through the Department of Labor or through court, to recover the pay that they should have received. So with that, happy news. Now I want to talk about some things that are not changing yet in New York. There was a lot of concern about some call-in pay rules in New York. I actually did a webinar on this topic back in February when it was anticipated that the New York State Department of Labor would be putting these rules into effect in short order, only to then a couple of days after the webinar have the Department of Labor come out and drop the proposal. They had proposed rules in both 2017 and 2018 to make significant expansion of the call-in pay rule that's currently in effect for most New York employers. So that's off the table, but the Department of Labor has indicated possible legislative action to address concerns related to unpredictable employee scheduling. So I don't anticipate the issue is going to die entirely. The Department of Labor just felt that it could not handle the issue through regulation alone. Here's what they were trying to do through regulation. This is the current rule that is really limited in when it applies, but for some employees who are essentially called into work less than 4 hours, if that's not their regular scheduled shift, they might be entitled to some additional pay, but only if they're not already paid enough money above and beyond the minimum wage to account for this additional time. If you want more information on what that means and the proposed changes, like I said, you can find my earlier webinar through my website. But here is what the proposed rule would have added. Everything you see on this slide in micro font and everything you see on this slide in micro font. The Department of Labor wisely recognized this was not going to work. This is what they have put on their website about this. Based on extensive feedback, it was clear the department's initial intent to support workers while being fair to businesses was viewed as a one-size-fits-all approach that was not appropriate for every industry. Comments on the revised rules issued in late 2018 indicated that significant issues remained, and the revisions did not achieve the balance of certainty and flexibility for either workers or businesses. Therefore, due to the constraints of the regulatory process, the best course of action is to let the process expire and reevaluate in the future, likely in concert with the legislature. So stay tuned on these issues. Something else that would have had a dramatic impact on employers throughout New York State was a proposed amendment to add bereavement leave to the state's relatively new in itself paid family leave law. Both houses of the New York legislature actually approved this amendment in June of last year with bipartisan support. Governor Cuomo didn't receive the bill for action until late in the year when he vetoed the bill in December. The proposed amendment would have pretty simply added bereavement leave to the list of categories of leave allowed under the new paid family leave law. So it would have allowed up to 10 weeks of bereavement leave, which ultimately extends to 12 weeks, like for the other forms of paid family leave, to be taken each year effectively in any increment at any time. There was no attempt to revise the paid family leave law to account for, well, how long after, before, around a death, a funeral, services, etc., can someone take the leave, and can they take it consecutive days, a day at a time, part day? So really, I think most reasonable people who had a chance to work it all through would have realized that that amendment was totally impractical as passed. And the governor, in vetoing the legislation, did suggest that he'd be happy to consider alternative approaches this year. So certainly anticipate additional legislation in Albany to address the topic of bereavement leave. We don't know yet what form that will take, whether it will still be in the paid family leave law. And really a huge problem with these proposals was that there's no way that employees would be able to pay enough money into the paid family leave program to account for the potential utilization of this bereavement leave, based on the unfortunate reality that, employees from time to time are going to have family members who unfortunately pass away, and some may choose to take time off. Obviously, there's tremendous impacts on employers as well, who have to have employees missing time and deal with potentially short notice and sporadic absences. So not to ignore the importance of grieving and the realities of needing time off to do that, but this law as proposed was not really well situated to address many of the issues, and we will see how they likely do get addressed going forward, or at least hopefully get addressed, because this issue is not just going to pass away. Okay, so that's all the updates I want to discuss at the state level that have either actually happened or so far not taken effect. Just quickly, I want to comment on a couple of local laws affecting certain parts of New York, for two reasons, as I mentioned earlier. One, if you happen to have employees in these areas, you need to know about these laws. And two, because these types of laws are indicative of things that are happening or may soon be happening at the state level. New York City's sexual harassment training requirements took effect earlier this month on April 1st. So New York City employers with at least 15 employees are required to conduct sexual harassment training for all employees each calendar year. Of course, you should all be familiar with the New York State sexual harassment training requirements that actually apply to all employers. So even beyond those with 15 employees, such as the New York City law, but the New York City law does require additional components of the training, and unlike the state law, it does require calendar year annual training. So the law took effect April 1st. You have to train all employees in New York City by the end of 2019. The statewide law takes effect October 9th of this year, but you don't necessarily have to use a calendar year for your retraining. You can use, for example, the October 9th effective date probably as the annual date. You could use anniversary dates of the training, for example. So that could put you on a different schedule in what is required in New York City. And like I said, there are some additional components you have to satisfy the New York City training. Like with the state training, New York City has issued sample training programs that are designed not only to meet the New York City requirements, but also the state requirements. Just going down, the other New York City law I mentioned on here is a change to New York law regarding employers providing lactation rooms for employees. again, applies to employers with 15 or more employees. They have to provide reasonable unpaid or paid break time in a private space to express milk. There have been, for some number of years now, state laws of a similar nature that apply, again, more broadly to all employers, but there are some specific requirements in the New York City law that are not in the state law. For example, requirement of a refrigerator and nearby running water in proximity to the room. I mean, there's still allowances for situations where it'd be an unreasonable hardship for a particular employer to actually have a physical room that meets the standards. But again, if you are in New York City, you want to be familiar with that law that took effect in March, because it is in some ways different and more expansive than the statewide law. Westchester County has a new earned sick leave law that took effect last week. Private employers with at least 5 employees in Westchester County must provide paid sick leave, and other employers must at least provide unpaid sick leave to employees. I'm not going to get into the details, but it's an accrual over time basis with caps on how much you have to allow employees to use in a particular year. New York City has already had paid sick leave laws for several years now. The Westchester law is similar, but obviously expanding out of the city somewhat. And then expanding onto Long Island, you have the Suffolk salary history ban. Similar laws are already in effect in New York, Westchester, and Albany counties, I believe. So coming up in June, Suffolk County employers with at least 4 employees will no longer be able to ask about or rely on salary history information for prospective employees. This means not only can you not ask someone how much you made at a previous employer, how much you're making now, for example, but if you get that information, either because the applicant volunteers it or you get it through public sources or something like that, then you cannot use that information in setting the employee's salary or deciding whether or not to hire them, etc. So again, I don't know that anyone on here has employees in Suffolk or Westchester County, for example, but regardless, I wanted to highlight those because they are indicative of trends within the state. And here are some things that we should be watching out for as early as this year. Paid sick leave, which is in place now in New York and Westchester counties, is certainly something that will be and has been discussed in Albany and could at some point in the not too distant future come into play statewide, even beyond the existing disability insurance requirements. The paid FMLA, of course, would be a federal law. New York has its paid family leave law, but the federal level, the FMLA is still unpaid. This is an issue where even the president has supported proposals for paid FMLA. No guarantees that it will happen, but it is something that could happen despite the general federal situation against further employee protections and employer restrictions that we have right now. Finally, the equal pay issues. This would include measures like prohibiting employers from asking about or considering salary histories, which are primarily designed to protect women and promote higher pay for women. But that's not the only type of measure that could fall into this category. There are already, of course, existing laws that prohibit employers from discriminating in compensation of men and women, but those laws can be tweaked and do vary from state to state and at the federal level, so there could be changes in those areas. All of these are probably towards the top of the list of big picture issues that could realistically come into play within, say, the next year. Again, no guarantees. And as I mentioned, the bereavement leave and call-in pay issues are likely to be on deck in Albany as well. I'm sure there will be other issues that will affect New York employers developing over the next several months. And as I said before, we will continue to do our best through our blog on the website, hortonpllc.com, and through our newsletter and through future webinars to keep you all updated on what is going on and how it will affect your organizations. Shameless plug just before I get into the question and answer, but please start answering your questions. Last year this time I published this New York management law. It's a paperback handbook for employers in New York that discusses a lot of topics, including some of the ones on the screen. Obviously, it doesn't address the stuff that we've been talking about in today's webinar, but some of the basics of employment law at the federal level and the New York State counterparts and distinctions. So if you want that, it's available online through Amazon and Barnes & Noble, and those types of resources. But now let's take the questions and answers. Still a number of you on here. We have a few more minutes before our hour is up. And like I said, if there are questions, I will stay on. So any questions about any of the topics we discussed or others, I will sit back for a minute and let you think and type in your questions and then prepare to give the answers. Remember that this is not a private conversation, so the attorney-client privilege does not apply, so don't give too many specifics or anything that you wouldn't want others to have access to in your questions. If you do have more personal questions or need assistance in other areas beyond what we've discussed today, here is all my contact information, and you can always reach out to me and let me know what other topics you'd like to see in webinars as well. It's not always updates. We go back over some of the tried and true day in and day out issues of employment law compliance that many of you deal with as well. I will make these slides available. By the way, you will all get, if you're registered for this webinar, an email probably tomorrow with a link to both the replay of the webinar recording of everything I've said today and a link to the slides, but I will put that up in just a moment so you can download the slides for your reference. Otherwise, with Easter coming up, I hope you all have a good weekend. Thanks for taking your time out to be able to participate today. If you have any questions, go ahead and type them in, but let me put that link up to the slides. All right, I don't see any questions yet. If you thought you had submitted one, it hasn't come through, so try again. Maybe I either gave you enough information to dwell on for now or scared you in some way and now you're running off to deal with that. But regardless, all my contact information, like I said, is on the screen. If you have any follow-up questions, you can let me know separately or afterwards as well. But I will give about another minute to see if any questions do come in. Still not seeing any questions. There's still a number of you here. If you have a question, you're trying to formulate it in your mind before you ask it, type something quickly so I don't log off. But otherwise, I'll just assume that you have enough information for now, and you will stay tuned for our email newsletter and future webinars and announcements so that you can stay informed of what's going on. But again, I appreciate your time. Thanks for attending and participating. I hope it's helped and look forward to speaking with you again in the future. All right, with that, I am going to sign off. Thanks again. It's been my pleasure. Talk to you soon.